where do the rights that we have that are embodied in the Constitution come from? Do they come from the government? No, they are natural rights. And there is a distinct difference of opinion in the Supreme Court between the origin, whether we're talking about the rights came from God and natural rights, or whether we got them as supplicants from the government. So I'm in the natural rights arena. So basically what happens is the genius of our system, our constitutional system, is that there is a separation of powers. The Constitution defines three different branches of government. The legislature, which makes the laws, the executive, which is supposed to faithfully see to the execution of the laws, and the judicial branch, which then interprets the laws and says what the laws really mean. There was an early case before the Supreme Court as far as whether or not the executive could overrule the Supreme Court, and in a very famous case it said, no, the Supreme Court is the Supreme Court, it's the law of the land. The law is what the Supreme Court says it is. Okay, so that's what we're dealing with. Article 3 is what establishes the judiciary. And it says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which will not be diminished during their continuance in office. This means that judges in the federal court system are appointed for life. The appointment process is, as you know from having watched the Kavanaugh circus, is that the nominees are made by the president, and they must be with the advice and consent of the Senate. Now, there's nothing in the Constitution that says that the Senate has to have 60 votes. The Dems had that rule. 60 votes was cloture to cut off debate and finally vote. A couple of years ago, when Harry Reid was the majority leader, they changed the rules after a big fight so that all federal court nominees, except the Supremes, could be done just on a majority vote. And then with Mitch McConnell coming in and these vacancies, the two vacancies with Gorsuch and Kavanaugh, changed the rules so it's a majority vote for all the federal judiciary. And they serve for life. The only way you can get rid of a federal judge is by impeachment, and there's a whole process here. And I don't think any, I know no Supreme Court justice has been impeached. I do know of a district court judge who's been impeached because I had a case in front of him before he was impeached. I'll tell you about that later. Okay, so what happens is we've got a 9-member Supreme Court. Did anything in there say anything about 9 members? No. The size of the court has varied from time to time, but right now it's 9. It's been less. And when Roosevelt was not happy with some of the rulings that declared unconstitutional some of his New Deal legislation, he attempted to pack the court by increasing the size to 13, and he would have all these extra appointments, and of course the country rebelled and that never happened. So what we have is in the federal court system, we have 3 levels of courts. We have the district courts, and every state has a district court, at least one. New Hampshire, being a small state, has 1. Florida, where I used to live, big state, has 3. New York has many. California has many. Okay, so that's the basic trial court. And then if you're not happy, you can appeal to, the country's divided into a bunch of circuit courts of appeal. And this map back there shows you the different courts of appeal. Now, our court of appeal from New Hampshire is the first, which you see is New Hampshire, Vermont, Massachusetts, Rhode Island. And that court sits in Boston. And then if you're not happy with that, you can try to go to the Supreme Court of the United States, to SCOTUS. Okay, and I'll talk about that process. In New Hampshire, we have a Superior Court or a Circuit Court, and these judges there and the New Hampshire Supreme Court are appointed by the governor with the consent of the Executive Council. And there's an age limitation. You can impeach them, but when they turn 70, they're gone. Okay, so when you If you're not happy with the outcome in the New Hampshire State Court, you can basically file an appeal to the New Hampshire Supreme Court, and unless it's a death penalty case, which we don't have many of those, where you can then go into the federal system after all this, you basically one and done. You got the trial court, New Hampshire Supreme Court, 5 members. What they say, it's one and done. Over with. Okay, U.S. District Court. The federal courts, you can ask, sometimes the legislature, sometimes the governor, sometimes a state official will ask the New Hampshire Supreme Court for an advisory opinion. What do you think about such and such a proposed law? What do you think about this issue? And they can decide whether or not they'll give you an answer. And they sometimes do, many times they do. There are no advisory opinions in the federal system because the Constitution says, Section 2 of Article 3, the judicial power shall extend to all cases in law and equity arising under this Constitution, blah, 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 blah. And then in cases involving ambassadors, public ministers, admiralty and maritime jurisdiction, controversies to which the U.S. is a party, controversies between 2 or more states, and then between citizens of different states. And it goes through all that stuff. So if you have an admiralty case, you're going to be in federal court. If you have a dispute between, as there's a long history of disputes between New Hampshire and Maine over the boundary between the states in the Piscataway River that comes down there in Portsmouth. And of course, New Hampshire says it's closer to you, Maine, because that's our land. And Maine says, no, it's closer to you because this is ours. And that has been fought twice in the last 100 years in the U.S. Supreme Court. And the last time, Justice Scalia said, you guys fought it out 100 years ago, we're not going to hear it again. So, anyhow. So, you got a district court where you have your basic stuff. And then if you're not happy, you don't have to get permission. You can file an appeal in the Court of Appeals. And the Court of Appeals will hear it and make a decision. And if you're not happy with the decision there is a possibility of going to the Supreme Court. If, other than these specialized cases here between 2 states, which has original jurisdiction there, you have to go, it's all discretionary. Basically, in the handout, I talk about that these are Article 3 courts. These are all Article 3 courts. There are other courts, there are other federal courts. And I've listed some of these others on the second page, the back of the first page. There's some Article 1 courts with specialized jurisdiction, such as bankruptcy courts, tax court, court of federal claims, immigration courts, blah, 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 blah. The difference is Article 1 courts, the judges are not appointed by the president and confirmed by the Senate. They're not appointed for life. They have limited terms. Some people, some lawyers who are a little on the snarky side say Article 1 judges aren't real judges. The bankruptcy judges used to be called referees in bankruptcy. Magistrate judges, which hear a lot of the preliminary stuff in the district court for the judges to take some of the burden off of them, they now call them magistrate judges. They used to be called magistrates. So there's a lot of miscellaneous courts, and then there's a couple of Article 4 courts, High Court of American Samoa, stuff like that. So in each of these courts, each of the federal courts, you have to actually get admitted to the bar of those courts. So when I took the bar exam and I got admitted to the New Hampshire courts, I could go into any state court in New Hampshire. The same time, same day, we all trooped over to the district court here in New Hampshire, and we all got sworn in there by Judge McAuliffe, who was then the chief judge. So I could go into district court, and I haven't bothered to go to the First Circuit to get that admission, but I'm admitted in the 11th. I used to be admitted the 5th before it split. And in any event, I'm also admitted in the tax court, and I'm admitted to the bar of SCOTUS. To get admitted to the bar of the Supreme Court of the United States, they use a very important test. First of all, you have to be nominated by someone who is already a member, and then they put a mirror under your nose, and they see if it fogs up, and then they send you a certificate after you've paid them the fee. Okay, so it's not a big deal. But there is a whole subculture of lawyers who do the arguments and do the briefs before the Supreme Court of the United States. It's a very specialized practice. But I'm going to tell you a little bit about that. Now, how do you get into federal court? You don't get advisory opinions, but let's say you have a fight. Okay, so you want to sue, suppose you get sued here in New Hampshire by somebody from out of state. Normally you have to go to where the defendant is. You live here, they sue you here, and that plaintiff doesn't like the fact that you've got a home court advantage because you're a New Hampshire person. So if the amount of controversy is over $75,000 and there is complete diversity, in other words, you're a citizen of New Hampshire and they're a citizen of Maine or New York or something like that, that case can go into federal court with the notion that the federal courts are less likely to be influenced by local considerations. That's the theory, at least. Now, what law do they apply? They apply federal procedural law, but the substantive law they apply is New Hampshire law, the law where they are sitting, the substantive law. Okay, so you're not happy with the Court of Appeals, and you ask the Supreme Court to hear it. How do you do that? You file a petition for a writ of certiorari. I define certiorari, it's a Latin term to be certain, and what happens is you have to file a petition and then a brief, which is nothing more than this long legal argument citing cases about why it's important for the Supreme Court to take the case. So that's the petition and brief on the writ for a writ of certiorari. Your opposition will file a response and brief why it should not be granted. Okay? Out of over 1,000 cases, petitions for cert, each year, Supreme Court grants cert in about 1.1% of the cases. Okay? So what will happen is in the Supreme Court Reporter, which you can see online also, you'll see every week that they're sitting, they'll issue a blanket order and say, cert denied, and they'll have case after case after case after case after case. Very simple, no explanation. It used to be that when Justice Brennan was on the court, Justice Marshall was on the court, they would say, cert denied, Mr. Justice Brennan dissents, being of the view that the death penalty is unconstitutional in all events, or something like that. Basically, that was sort of the standard thing in those years. Okay, so let's suppose they decide. Why would they decide to take a case? Well, I have some different things here about what they do, typically what they like to do. Okay, if you've got these courts of appeal, you have these 11 courts of appeal plus some specialized ones, and you have one that decides a legal issue one way, and another one that decides the same issue the other way. A conflict between the circuits. That is a typical case for resolution by the Supreme Court. The other one is if it's of great public importance, like Bush v. Gore, the election, Roe versus Wade, etc. U.S. versus Nixon. Okay, so after they say they should order, certiorari is granted. Now, the petitioner has to file another brief, which is a brief on the merits with their argument. The opposition files a response brief, and then the petitioner has a reply brief. And then, usually they'll set it for oral argument. They don't set every case for oral argument, but most of the ones, the few that they have oral argument. After oral argument, usually every week, the 9 justices get together in a conference room with only them, no clerks, no assistants, no nothing. They discuss the cases, they take a preliminary vote. The Chief Justice then assigns the job of writing the majority opinion to the senior-most justice in the majority, and the minority, any dissent, to the senior-most justice in the minority.
Grok TV.